I'm Jody Litton. Today's sexual harassment training has been approved for 1 hour of credit through DLG. For those that are eligible, please make sure and leave your camera on so we can see you. Also, if you are taking this class, if you took the class on March 7th, you cannot get credit for it again. You can only get credit for it one time. So just keep that in mind. You're more than welcome to stay on, but you just can't get credit. Please make sure you stay on mute to keep your background noise to a minimum. Make sure your name is displayed correctly. And if you have any questions, you can either type them in the chat box or you can raise your hand and then unmute yourself when called upon. With that, let's get started. I'm going to now turn it over to Carol Pettit with Von Pettit Legal Group.
Good afternoon, everyone. Here to talk today about sexual harassment in the workplace. I see a few familiar names up there. It's my understanding that everybody here has some sort of supervisory role in county government. And so the things that we talk about today are going to be geared toward that. This is who I am. This is my contact information. I am a partner with Von Pettit Legal Group. I focus my practice entirely on the defense of governments, elected officials, and folks that work for government. So my area of expertise, although the Kentucky Bar Association doesn't qualify us as experts, my area of concentration, perhaps is a better way to say it, is just that. So this is my wheelhouse, and I do deal with a fair amount of sexual harassment claims, both pre-litigation and post-litigation. And we're here today to try to keep you from needing my services, for lack of a better way of saying it. I know that if you have questions throughout today, you were told raise your hand and then unmute. I can't see you, so I am good with you just raising your hand, unmuting, and kind of shouting them out. I have 3 children and I have several employees, so I'm used to kind of the, I don't know, game of asteroids, the plane just having questions shot at me. So I won't be able to see you, but it won't startle me at all. Just please unmute after you raise your hand or whatever and shout out the questions, and I'll be glad to address them. If you have questions that are specific with regard to a scenario that is occurring currently or that you anticipate might occur in the future, it's probably best to wait and ask those specific questions afterwards. My contact information is there on the screen in front of you. That is the landline to my office. I am very rarely there, but you are free to call that number and leave me a voicemail. We're going to discuss today what is sexual harassment. Some of the things that we'll discuss today are obvious. You will know, yes, clearly that is sexual harassment. Some of the things that we discuss today will not be so obvious, and we're going to also talk about how to avoid them and what to do if those things occur. The definition of sexual harassment is an unwelcomed verbal, visual, or physical conduct of a sexual nature that affects working conditions. Not everything that might be perceived as sexual harassment will become sexual harassment from a legal perspective. It becomes unlawful when the conduct or the language or the visuals are a condition of continued employment, or if that conduct is so severe and pervasive as to create a work environment that a reasonable person would consider hostile or abusive or intimidating. The reasonable person standard is established by the federal courts. And the severe and pervasive requirement is something that we should keep in mind. I'm certainly not encouraging folks to make comments that they know might be offensive, might be over the line, and we all know, or we should all know what those are. But I am telling you that if there's an isolated incident and somebody simply makes a mistake or misspeaks or says something they know they shouldn't have said, that is not going to be considered sexual harassment as far as the courts are concerned. It must be severe and pervasive, which means it's an ongoing thing. I think that most of us, when we think of sexual harassment, think of men harassing women, but it is not always what you think. That tends to be what I see when the lawsuits come through. It tends to be what we see in the headlines and the news, but it's not limited to that. The victim of sexual harassment or the complainant in the civil realm does not have to be of the opposite gender. It can be a male or a female. Unlawful sexual harassment can occur without an economic injury or the discharge from employment of a victim. So I think we all know that if you make some sort of sexual favor or listening to sexual jokes a condition of employment and you dock somebody's pay for that, that's obviously going to be something that we shouldn't do and something that's going to be actionable. However, it doesn't always have to be that. Harassment doesn't have to be intentional to have an harassing impact, and that's something we'll talk about a little bit later. Throughout the day today, I thought, or throughout the hour, I don't want you to think I'm going to keep you here all day, but throughout the hour that we're together today, I thought it might be helpful for you all to see some concrete examples of things that come across my desk, things that I am called in to defend. So I have put several examples of those in my PowerPoint today, and I have redacted identifying information. So on the screen right now is an example of harassment that can happen both on and off the job. You can read it for yourself, but what this has to do with is an allegation that was contained in a complaint that was filed, and it had to do with a supervisor's Facebook post. This goes back to just a few minutes ago where we said it doesn't have to be intentional and it doesn't have to be meant to be harassing to perhaps be defined as sexual harassment. So in this particular excerpt, the supervisor posted on that supervisor's personal Facebook social media site with words to this effect: how to calm an angry woman, works all the time at work, and you can read the rest of it for yourself. Now, this particular post was not said to be about any particular individual, and there wasn't any evidence that it was about any particular individual. However, it was one of the allegations, and that's something that we had to discuss and something that I had to defend when this particular lawsuit was ongoing. I tell my folks at the beginning of a lawsuit, and I think this applies to perhaps the whole topic that we're discussing today, our defense is better if I have less to explain. So social media posts like this, especially when you are friends with coworkers or subordinates on Facebook or social media sites, are something that we should try to avoid. Even if an individual doesn't express that it bothers them or they think that it's about them, down the line when people get upset about other things, they can certainly use this as an example of something that they believed was sexual harassment at the time, whether or not that tended to be true or if there's any evidence to substantiate it. So it's best to just avoid these types of things. We're going to look at two scenarios. And I'm going to ask you to tell me if the scenario is harassment. Scenario one, and these are both on your screen in front of you. Leslie and Ben share a computer at work. One day, Leslie is scrolling Facebook when she got called away from the computer, and she unknowingly left her Facebook account logged in. When Ben arrived for his shift, he began scrolling through Leslie's Facebook page and found, it says a PG-13, but I'm just going to tell you this is an example from a real lawsuit, and I would call it much more than a PG-13. Photograph. He left it up on the computer, told other coworkers about it. Do we think that is harassment? Scenario two. Michael is Pam's boss. One day he told her to go into an isolated storage area of their office. He followed her in and closed the door behind him. He told Pam he'd slept with other female employees at the office and bragged to Pam that he was so good at sex, one of the women didn't want to get out of his bed. He then asked Pam to bend over and pick up a box. She refused and left. The answers. They both are. One is more subtle than the other. but they are both sexual harassment as defined by the applicable authorities, at least according to the attorneys that filed the lawsuits. These are both real examples from real lawsuits that have occurred in the past. Sexual harassment can include offensive remarks about a person's sex. And again, on this screen, there are some excerpts from lawsuits that are real, that have been filed in courts, and that have been defended and litigated. Making insulting comments about someone's gender identity or sexual orientation. That's something that's kind of new to us. I don't know over the last however many years, but the gender identity issue certainly is somewhat new, especially to those of us that have been in the workplace for a period of time. If you look at the examples that are there on that page, paragraph 16, from the day that jailer took the office as jailer of this county, it became obvious he had a problem with women that worked at the jail. He would constantly undermine their authority in front of subordinate employees and inmates alike, yell, cuss, and berate in a concerted effort to run them off. Now, a lot of us can be very direct with our words. A lot of us can be to the point. It's just the nature of the environment in which we work. What we look for when we're defending these types of lawsuits, and if we're trying to ascertain if there has been sexual harassment that's based on someone's gender, is, does it happen to women exclusively? Does it happen to men exclusively? Does it seem to be that the gender is the determining factor as to whether you are the recipient of this type of behavior? That's something that is not as direct and that is not as obvious and that we wouldn't necessarily think of as sexual harassment, but that is something that the courts tell us we need to be cognizant of. In a different lawsuit, which is also on that same page, in other instances, this individual, whose name has been redacted, was asked by a male supervisor to leave roll call so that he could talk directly to the male officers about her because she was a female and she was on this shift. This is something that's also, I believe, was unintentional. In this particular instance of that lawsuit in which that issue arose, I believe that it was well-intentioned. A lot of county government, jails, if you have a police department, sheriff's office, those tend to be male-dominated professions. And I believe in the example that is in front of you, that supervisor had all the good intentions. He was trying to make that workplace more comfortable, a better place to work for that female who was well in the minority of that male-dominated field of law enforcement. However, that is, again, let's go back to what we just talked about. Is it something that that individual is being subjected to based only on their gender? In that instance, although it was well-intentioned, the answer to that question is yes. So when that female felt singled out because she was a female, even though it was for a good intention, that is something that we should try to avoid. There are 3 types of sexual harassment. The first is verbal or written. That includes comments that are made about clothing, personal behavior, a person's body, sex-based jokes, requesting sexual favors. That one's pretty obvious. Repeatedly asking a person out on a personal engagement or a date. Sexual innuendos, rumors about a person's sex life, and sending emails and texts which are sexual in nature. It does not matter if you only forward them. They simply should be avoided. Second type, this is more obvious. I think we all know this, but there are some less than obvious aspects to it too. Physical sexual harassment includes brushing up against people, touching of a person or their clothes, kissing, hugging, patting, and stroking. So this becomes a particular challenge when we have individuals, and I would say that most of the people that I encounter in county government are very personable. They're people, so to speak, and people like them. This goes especially for our elected officials, because if you weren't a likable person, you wouldn't get elected. There are people they're touchy people, if you know what I mean. I'm a touchy person, not in my professional life, but I like to wrap my arm around someone. I like to pat them on the shoulder. I like to give their forearm a squeeze or something if I'm emphasizing something. In the work environment, that's something that we need to be cognizant of, not because there is anything wrong with our intentions, not that we are intending to be harassing or to bother that individual. But remember back at the beginning of this when we started talking about a reasonable person, how they would perceive it. So everybody perceives things differently. Some people are receptive and understand that a arm around the shoulder or a pat on the back is simply something that is meant to communicate a positive affirmation, or you're doing a good job, or I really like you, etc. The person that's receiving that might perceive that as uncomfortable. Might make them uncomfortable. They may just be one of those people that don't like to be touched. I had a lawsuit years ago. It was in a jail setting, and there was a female deputy jailer, and she was upset about something. She had a male supervisor, and as they were walking down the hallway, he was trying to verbally comfort her. He put his arm around her shoulder and just gave a pat. It's innocuous, and there was nothing that I believe he intended to be offensive, or he did not intend that gesture to make that female employee uncomfortable. However, you bet your sweet Beppy, it was in the lawsuit. Once something else came up that individual found to be offensive, and she filed her lawsuit, she put it in there that was sexual harassment. So we need to be cognizant not only of our intentions when we are touching people, but of what their perception might be. The safest bet, quite frankly, is just don't touch people at work. Quid pro quo. Everyone knows this. This is the age-old, this is sexual harassment. It literally means this for that. This is where something occurs, where something is offered in exchange for some benefit to that individual. If you go out on a date with me, you will get that promotion. Going back to my example earlier, if you bend over that box and stand there, then you will get to work this shift, or you will get that raise. Quid pro quo is never going to be okay. So we should play it safe. Don't test the parameters. And let me be further clear about this. All those things that we just talked about, even if you wrap your arm around an employee's shoulders and then you say, I'm sorry, I shouldn't have done that, that might have made you uncomfortable. They're probably going to say it didn't make them uncomfortable. But I guarantee you something, if that person is sitting there and this keeps happening and there's eventually a basis for some sort of complaint or lawsuit, that's when they're going to tell you it made them uncomfortable. People having to tell you it didn't make them uncomfortable makes people uncomfortable. So they're not going to do it. They're simply going to say, it's okay. It's not okay. We should just avoid it and not do that. Be cognizant of your actions. Be cognizant of the effect of things that you say, even in a joking manner, in the workplace. Because the answer, as you just saw in that video, is almost always going to be, it's okay, because it's uncomfortable for the person to say anything other than that, especially when the person talking to him or her is in a position of authority, especially in the case of this video, that is a supervisor talking to someone who's a new employee. Just because she says, or he says it's okay, does not mean it's okay. The effects of sexual harassment on the victim or the recipient of the comments or the acts or the communications. They can feel guilty about it. There can be changes in their appetite and sleep disturbances, an inability to focus, feelings of shame and doubt, increase in the risk of cardiovascular disease, aches and pains, PTSD, loss of employment, humiliation or defamation, and depression. I see, I don't know how many hundreds of lawsuits come across my desk at any given time. Sometimes we kind of know that it's someone that is making a mountain out of a molehill and these things didn't actually occur, or they're not as significant as they are made out to be, perhaps because that person has the intention of monetary gain, getting some money out of this. But I will tell you that the jury is going to perceive that, and the judge is going to perceive that, and they're going to look at it through the eyes of that person. If that person can communicate that it genuinely affected them, and these are some of the things that we see, then we're going to have a hard time defending that lawsuit. Sexual harassment is actually illegal. There are federal and state authorities that control that. They are listed here on the screen in front of you. Sexual harassment can also have non-legal impacts on an entity, such as decreased productivity, increased turnover, and damage to the reputation. Damage to the reputation is perhaps the hardest thing to overcome. If your organization or one of the departments within the county gets a reputation for that, it can take years to overcome that bad rap that you've gotten in the public. You can have problems with retaining employees and with hiring employees because that department or that area has gotten that type of reputation. I think we all know how hard it is to find new employees and retain good employees. Defending a sexual harassment claim, and the reason why I'm saying claim or lawsuit is a lot of times what we see is these go through as EEOC complaints. So it's not technically a lawsuit. So we'll see an EEOC complaint or we'll see a lawsuit, but it's expensive. It's expensive to defend, and there can be some really bad verdicts. Those are listed down at the bottom of this slide. The 168 million, 95 million, $20 million. What are our duties as a coworker or as an employer if we see or we reasonably believe that something like this is happening? There may not be an actual defined duty for the recipients, for the confidants or the witnesses to these actions or words, but just because there may not be a legally defined duty or a duty defined by the policies and procedures of the county doesn't mean that you shouldn't say something. An employee should report harassment when they are aware that it arises. Sometimes these issues can become very emotionally charged and can lead to workplace violence if left unattended. As an employee, you should want to have a healthy and safe workplace, and as an employer, you should want to create one. So, I don't want to sound trite, but if you see something, you should say something. Most of the county's policies and procedures for personnel that I have seen have some sort of hierarchy defined within them, saying who that individual should go to report this type of behavior that is concerning. If you are that individual that the behavior or the concerning words are reported to, it is very important that you keep that in the highest of confidence. Failure to keep such things in confidence will lead to I hate to use this word because it's so trite, but a toxic workplace where nobody will report anything. And that type of environment tends to breed lawsuits, employee discontent, high turnover, and the inability to retain employees. As a supervisor, you are legally responsible for the safety, security, and well-being of the employees. The federal statute that defines that is here on the screen in front of you. And if anyone wants a copy of this PowerPoint after we're done, so you don't have to scribble down the actual codes or statutes that are cited in here, just give the folks here at KACo a holler, they can get it to you, or I'd be glad to get it to you as well. So don't be shy about doing that. An employer, a supervisory employee, has the duty to protect its employees from things that they know or they should have known. One example that I have had from my personal work life that I often cite during these presentations, you are not only bound to protect your employees from other employees or from supervisors, folks in management within your county government, but you are also required to protect them from the actions of others in the workplace. I had a situation years ago. We had a delivery man for one of the big delivery companies. We won't define it because I don't want their lawyers watching it coming after me. But you know, it was one of the folks that comes and delivers the packages every day. I would frequently run into him in the elevator. I thought he was very pleasant. He was actually related to a couple of lawyers that I knew. He never said anything inappropriate to me. One day, I was talking with one of the administrative staff members, one of our legal assistants, and she said to me, "Can you believe the things that he says?" And I had no idea what she was talking about. She proceeded to tell me that when there was no one in a position of authority around, so one of the other lawyers, whether it be a male or a female, if it was one of the staff members, a legal assistant or a receptionist, that this individual made everyone very uncomfortable. And she gave me examples of the things that he would say to our female employees when there was no one in what he perceived to be a position of authority around. And they were unbelievable. You have a duty to protect your employees from people from the outside. So we did that. We went to that particular company, advised them of the conduct of their employee, and were assured and were provided with documentation that action had been taken for that behavior. And that's what you can do. That's what you are bound to do when you are the supervisor or the management, and there is an individual from outside of your agency that is engaged in this type of behavior. It could be a vendor. You know, for the jails, it could be whoever you contract with to do healthcare or kitchen work, any of those folks. Those are not your employees. They are employees of outside vendors, and you have a duty to protect your employees from harassment by those folks. It is better to investigate complaints, and that's with a lowercase c, before they become complaints with an uppercase C. A uppercase C is the document that actually initiates a lawsuit. I've given you some more examples on this page of real life things that I have seen come across my desk. And we go back to one of the scenarios that we talked about earlier, one of my examples. On more than one occasion, this individual walked into roll call to find male officers watching pornography on their mobile phones. When she reported it, her complaints were ignored. If you have a complaint brought to you as someone in a supervisory capacity or in a position that has the ability to do something or to initiate an investigation, you must not only investigate it, or it's prudent to investigate it as soon as that is brought to you, but you should document what you did to investigate it. You should document who you talked to, the date that the complaint was brought to you, who brought it to you, in as much detail as you possibly can. It is sort of an elementary principle, but I can't emphasize that enough. You need to date the document. you need to put as much specific information in there as possible. I have gotten the best memos about items like these, and they don't have a date on them, which makes it much less effective when I'm trying to defend the allegations in the future. In another instance, the officers passed around a random picture on their mobile phone of an unknown female with her legs spread and joked that it was their fellow employee at the gym. She reported the incident to her supervisor at the time, and no action was taken. This individual complained of being discriminated against on a call with other officers, which she reported to her supervisor. Her supervisor scolded her, and nothing else was done. Now, again, this is from that individual's perspective, but if we want to protect ourselves against these types of allegations, and if we want to win the lawsuits when they come, then we should take action. We should immediately investigate, and we should document what it is we did, and we should retain that. The statute of limitations as to most of the claims that can be brought against a county government is 1 year. That is somewhat different with regard to state law claims in Kentucky. Up until just recently, under the Kentucky Civil Rights Act, the statute of limitations was 5 years. It has just recently been amended down to 3, or that is going to happen in the very near future. So a minimum of 3 years is what I would retain these items, just based on prudent practices from a legal perspective. Of course, you may have other requirements on the Department of Library and Archives for your record retention that are independent of just my recommendations of what is good practice. So you should be cognizant of those too. You need to make sure that your employees know what is required to be reported, who they report to. And if the individual is bringing a complaint to you, you should give them a general overview of how the investigation process is going to go so they feel assured that something is being done. I cannot tell you the number of times that I have gone in and I've talked to my elected official or my supervisory person, and there were things done. There was an investigation conducted. It may not have been overwhelming. There may not have been 100 people interviewed, but enough was done that it was sufficiently investigated. We still get the lawsuit. And when I asked that person in their deposition why they put in their lawsuit that I made these complaints and nothing was done, the answer almost always is, well, I didn't, nobody told me anything was done. And almost all of the time, something actually had been done, but we had failed to communicate that to the person making the complaint, which made them feel frustrated, made them feel unimportant, and made them feel as if their complaints weren't being addressed. So if we don't communicate it to the individual that something is being done, and perhaps the outcome of what was done, then we're still going to get these lawsuits because the person isn't going to know that anything happened and that their concerns were addressed. I've got on this slide for you a sample policy. It outlines a procedure. It defines what sexual harassment is. The things that this policy does well is it includes a general reporting procedure, and it does a good job defining sexual harassment. Things that could be done better with regard to this type of policy is a little bit more specificity on to whom to report to if the individual that is defined in this policy as who the go-to person is the one who's doing the actual harassment. Something that we see in counties a lot because we have so many constitutionally elected folks that really are islands unto themselves. but people don't always perceive it as such. So we have, constitutionally elected sheriff, constitutionally elected jailer, constitutionally elected county attorney, constitutionally elected county judge executive. What, for instance, should we tell our employees to do if the actual harasser is one of the other constitutionally elected people who has really no power to do anything to another constitutionally elected officer? An example that, the most common example is in the jail setting. When the jailer is there's a complaint against the jailer. Well, there's no one over the jailer. The jailer is on the same level as the county judge executive, the county attorney, the sheriff. But what I have counseled folks to do and recommended, and Mr. Ornstein here at KACo can certainly weigh in on this as well, even though the county judge executive or another constitutionally elected officer in the county doesn't have the power to do anything to another constitutionally elected officer, it would be good practice to put something in the policy to give the individual an outlet, to instruct them specifically to go to another one of the constitutionally elected officers in the county. Because the failure to put something of that nature in there leaves that person feeling as if they do not have any outlet for their complaint. And that is when we get the lawsuits. This next slide is just what I just told you because I get ahead of myself sometimes. One of the other biggest problems that we see is once a concern has been brought to someone in county government or city government, but in this instance, y'all are county officials and county employees, or once an EEOC complaint has been filed, which isn't public knowledge, but it is an official document and complaint, or a lawsuit. It is more common than not that there isn't a lot to that complaint. It's very defensible is what we call it. Even if something happened, it's not going to constitute any type of harassment or sexual harassment. But the bigger problem that we see is retaliation. Even if that complaint ends up being a whole bunch of nothing, even if it eventually, the lawsuit will get dismissed, or the EEOC complaint will be dismissed, or the internal investigation is going to come up unsubstantiated or unfounded, it's unlawful to retaliate against that individual for actually making the complaint. This tends to be something that's a little more challenging because even though we're elected officials or we're employees of a government, we're also humans. And sometimes the complaints that we see with regard to this particular subject matter can feel very personal. Sometimes they really are very personal. And human nature is to treat that person differently or to have our feelings hurt, to act kind of differently around them. So even when I have the most benign sexual harassment complaint, where I tend to run into most of my problems is because by human nature, consciously or subconsciously, we treat that person differently, which can oftentimes be construed as retaliation. And retaliation is illegal. When we have a claim of some sort of sexual harassment, it is crucial that we separate the person that is claiming to have been harassed and the harasser. Some guidelines that I can give you. When you separate that person that is complaining from the person that is said to have done the harassing, do not move the person that lodged the complaint. It is oftentimes the easiest thing to do. I'll go back to my jails just because they give me so much material for good examples. So in a jail, we have multiple shifts of people. We usually got a shift supervisor, then somebody above them, and somebody above them, and then usually the jailer. If you have a deputy that is on I don't know how you, it's not uniform, obviously, how you do your schedules, but say you have an A shift and a B shift, and of that you've got a night and a day shift. If you've got somebody that is on A nights and they have made a complaint against their supervisor, don't move them to B nights. Don't do that, because that can be perceived as retaliation. What I'm going to see when that complaint comes across my desk is, I made a complaint that I perceived was valid, and I was moved to B night shifts, which created financial hardship for me because it interfered with my childcare, and it interfered with my ability to take care of my ailing mother, so I had to pay somebody to sit with her. Do not make it such that the person that is lodging the complaint is the one that is moved, because it can be perceived as something that is negative. Do not give time off to the person that lodges the complaint. It doesn't matter if it's with pay or without pay. It can be perceived as if they were being punished for reporting, and quite frankly, I don't know why we would ever do that. So do not give that person time off. If you have any questions about this, because obviously every one of these scenarios is fact-specific, and any given fact or factor in your decision-making process can result in a different outcome or a decision on how to deal with this particular claim, please consult with your county attorney or somebody here at KACo, and just have somebody else to kind of run the idea by and see what they think. But the two major principles when avoiding retaliation claims, the things that I see most often are that we move the person that made the complaint, and then we give time off to the person that made the complaint, and we must avoid that. Here are some more real-life examples that I think everybody probably finds interesting. In response to the reports, the plaintiff was retaliated against. She was forced to take a demotion from supervisor. She was taken off her ambulance. This was, I left out my EMS folks. They gave me lots of examples too. She had her ambulance taken away. In this particular scenario, there was no assigned ambulance, but there was one that she routinely drove, and her perception was that it was taken away because she had made this complaint. It was actually taken away because she had caused damage to it. So again, there's two sides to every story. But let's be cognizant of that fact, that there are two sides to every story, and be careful the way we conduct ourselves once we know somebody has lodged a complaint. She had her partner taken away, lost shifts, was moved to night shift, was isolated from others, and told by several coworkers they wouldn't be promoted if they talked to her. On one occasion where she reported harassment in an email, instead of investigating it, the supervisor printed that email and approached her with it, told her she had a problem with him, she needed to bring it to him, she could find another shift, and don't ever undermine him again. I would recommend all of those, recommend against all of those things. Overview, question number 1. Vince is not responsible for the actions of Mr. Foster because Mr. Foster is not an employee. We know that to be false. Vince's statement that Haley would not receive a promotion and could even be fired if she did not simply put up with the harassment is an example of retaliation. Which of the following things could Vince have done to better respond to Haley's report? He could have memorialized that report in a dated writing to be kept in her file. He could have spoken with the individual that was subjecting her to the unwanted harassment. Could assign Haley to a different work, assigning Haley to a different work site could lead to another retaliation claim and is not best practices. What makes Mr. Foster behavior illegal harassment? We know there's two ways that harassment becomes illegal, where Enduring the offensive conduct becomes a condition of employment, and where it's severe and pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Both of these things are present here. Lastly, leave a few minutes if anyone has any general questions. Now is the time to shout them out.
Well, Carol, I have a question.
Yes, sir.
This is Chris Hounds. So we talk about the elected officials, then I guess the thing that's just, we can't do anything to an elected official. I mean, obviously the public elected them. So what, if any, if we have a person who comes, say, to the court or to, a committee or whatever and says, hey, I'm having a problem with, doesn't matter the person, I mean, any elected official, what do we do with that then? What do we do with that information?
Yeah. So, correct, there's no legal authority for anyone to do anything. And people often, perhaps not you, Chris, and other elected officials, because you really understand it, but the general public, I have found, doesn't really understand why county government can't do anything about an elected official. And, the reason why there's no authority for anybody to do anything at the county level is because that would effectively be interfering with a vote. That would effectively be overturning an election without any kind of due process. So there is, my recommendation would be to sit down and have a conversation with that individual. And oftentimes that can curb the conduct, that can bring it to somebody's attention where they didn't realize that either the conduct was being perceived as such or that it was bothering anyone. There is, of course, a statutory mechanism for dealing with elected officials, but that's way out of the scope of what I'm prepared to discuss today during this presentation. But my practical answer to you, Chris, would be sit down and have a talk with that individual. And if that's not productive, then, give me a call. People that don't know, Chris is from my county, so give me a call, or we'll have a discussion with somebody here at KACo about next steps.
Thank you.
Yep. Anybody else?
So Carol, how often does something have to happen before you act on it?
What I think I hear is, how often does something have to happen before it's pervasive and ongoing, kind of the standard that we've been talking about today?
Sure.
Yeah. And I think that that's in large part subjective, and it can vary from each factual scenario. I had a situation one time where there was an African-American employee, and, certain people are more sensitive to things than others, but I had an African-American employee who had a banana left on the dashboard of the government-owned vehicle that he, generally speaking, drove every day. And he perceived that to be racially insensitive and something that was harassing. That isolated incident in and of itself obviously is not going to be severe, pervasive enough and ongoing to constitute harassment in the eyes of the court. On the other hand, it tends to be the level of severity and kind of a balancing act with the severity of it. So that was not an overtly racist thing. That is something that he perceived to have racial undertones. However, if the scenario had been, there was a picture of a lynching from 1920 taped to his steering wheel, that obviously would be very concerning, and that would be unequivocally something that we would see as something that had racial undertones, blatantly threatening. So if you have one of those scenarios happen a time or two, that could be sufficiently pervasive and ongoing. If you have The lesser of the examples, a banana was left and he perceived that as something that was racist. And then an offhanded comment was made that he also perceived as racist, but others did not. Then the cumulative effect, you would need to have more of the lower level type of behaviors to constitute something that would be legally cognizable as harassment versus the much more serious examples. You wouldn't have to have as many of those. It's really just something that is subjective and has to be determined on a case-by-case basis. That's why I encourage you, if something like that starts happening, to talk to county attorney, call me, talk to somebody here at KACo, and everybody can put their heads together and decide when it becomes a problem. Any type of behavior of that nature should immediately be addressed. The problem is, of course, that sometimes you don't find out about it until it has happened several times. Did that help?
Yes, ma'am. Thank you.
Okay, thank you. Anyone else?
Okay, thank you,
Okay,
Carol.
looks like we're right at the 3 o'clock mark. If anybody thinks of anything else afterward, I welcome you to give me a call. And I'm always glad to discuss it with you. It doesn't matter if you're in one of my normal counties. I see some folks from the counties that I deal with a lot in here, or outside of that. I'm always glad to have a conversation and help my folks with any of the counties try to do the right thing and take care of business. I appreciate your time today, folks. Thank you.
Thank you, Carol.